So a question I've been getting a lot is, what are my options after an adjustment of status denial, which means your I-485 or green card application was denied by USCIS? So this is actually a pretty devastating situation to be in under the current immigration policies, because in a denied I-485 will most likely result in a notice to appear in immigration court. There might be some exceptions, like if you're in a valid H-1B, that might not happen. That happens to be one of the few dual intent visas that allows you to have immigrant and non-immigrant intent simultaneously. And it's not a violation of your status to show you have immigrant intent like it might be for other types of visas. But for most other people, a denied I-485 is very likely to result in removal proceedings. And something that's infuriating about that is they say in the denial letter that you have like 30 or 33 days to depart the United States or to file a motion to reopen or reconsider or try to appeal the decision. But sometimes even before those 33 days, you receive a notice to appear in immigration court. And my question is, what if the person left the United States? You're just going to begin their removal proceedings, and there have been some judges who refuse to terminate the removal proceedings. So a hypothetical situation could be where someone's denied adjustment of status, in complete compliance with the decision, they depart the United States, they get a notice to appear anyway, and when they fail to appear because they left the United States, they get a removal order in their absence. Most attorneys would probably be able to terminate those removal proceedings, but there was a situation somewhat recently where an immigration judge refused to terminate removal proceedings for someone who had passed away, had died. And the attorney submitted their death certificate, and the judge said this motion to terminate is denied because good cause has not been shown for their failure to appear at this interview. Totally wild, kind of crazy, but it goes to show that the incentives for immigration judges right now are to get as many removals as possible, and the ones who are granting a lot of cases are being fired and replaced by other judges who are, I use the word judge very liberally here because they're not unbiased decision makers. They have one objective, and for many people that is to order them removed. Now, with that said, there are still some amazing judges out there who have not yet lost their jobs, and those are the ones, I'm in a bunch of immigration attorney private groups, and we hear about them still granting asylum cases, cancellation of removal, still terminating. In fact, I just had one out of San Francisco terminate my removal proceedings for someone who had an old removal order from like 2010. We got it reopened by this judge. We got it terminated. So now the removal order is fixed and we could apply for adjustment of status with USCIS. So I'm not speaking poorly about all the immigration judges, but the newer immigration judges seem to be inclined to get as many removal orders as possible and not terminate removal proceedings. So the question becomes, if you attend an adjustment of status interview, and let's say it's a marriage-based adjustment of status, and after the interview, during the interview, the USCIS officer believes that the marriage is in good faith. So after the interview, you get an I-130 approval notice, which just means that you've demonstrated that the marriage is in good faith. And then, a month later, you get an I-485 denial notice. For example, under the new policy memo, they just say, as a matter of discretion, we're going to deny this adjustment of status. That's happening in far fewer cases than people assume, but it is still happening. I'm not going to deny that it is absolutely happening, especially for some people who've overstayed their duration of stay by a very long period of time. There are examples of it. I have heard of it. It is absolutely a real thing. So in that situation, if you do not depart the United States, and then you get a notice to appear in immigration court, what are your options? Well, I would say there are generally two options there. One is you can refile a new I-485 in removal proceedings. It costs much more to do that. So adjustment of status with USCIS for most people is $1,440 on top of the other filing fees, like the one for the I-130. And then in removal proceedings, you're going to have to pay that same fee plus an additional $1,600 government filing fee. So just government fees alone there are $3,000, and you're also going to have to pay an attorney like another 10 to 15 grand to defend you in removal proceeding. So that could end up in total being like 3 or 4 times what you were just gonna pay an attorney to file your USCIS package for you and make sure that your case was likely to succeed. So if possible, try to avoid getting your I-485 denied. You know, I say that somewhat jokingly because of course you're not gonna get intentionally denied. But when they are denied, that is the first scenario that plays out. The second scenario that could play out, and second option that some people will have, is if they don't have enough unlawful presence. So if your total unlawful presence in the United States is fewer than 180 days, at that point, we might be able to just transfer your approved I-130 to a consulate by filing form I-824, asking the judge to grant voluntary departure. And if you meet all the other requirements, you can voluntarily depart the United States. And if you don't trigger the unlawful presence bar by having more than 180 days of unlawful presence, you don't have any previous fraud, any criminal issues, or any other grounds of inadmissibility, and you're not from one of the 75 countries that are currently paused from getting immigrant visas to enter the United States. I put pause in quotes because it's really a ban, but they're calling it a pause, acting like it's temporary, but it's definitely not going away as long as the Trump administration is in power. Then you could, in theory, transfer your case to a consulate, timely depart, and adjust status from abroad. But that first scenario where you could also, in theory, get a notice to appear after you depart is a scary scenario to be in. So you really need to play it out with an attorney and make sure you understand what all the risks are before you make a decision. Okay, so another question I get is, yeah, but can't I just file an I-290B? The denial decision says I could file a 290B to reopen the case or ask USCIS to reconsider. The answer is maybe. You might have a decent argument for a 290B motion to reopen or reconsider or both. You would generally file a motion to reopen if there's new evidence that you have to submit for USCIS to consider, particularly if that evidence was not previously available. I have a case like that right now where I think we have a high probability of success. You would do a motion to reconsider if you think USCIS made a mistake on the law or their conclusion was clearly erroneous. They made some sort of mistake and you want them to reconsider. That would be an appropriate situation. Either one of those would be appropriate for an I-290B. But the problem with the I-290B is, so for example, the last one I did took 4 months to adjudicate, but there have been some people who've had theirs adjudicated in like 2 weeks or less. So it didn't really buy them that much time. And if it ends up getting reopened or reconsidered, great, you achieved what you wanted to achieve. But if it gets denied, it's still likely to proceed to a notice to appear. And another scenario that I've seen, not in my specific practice, but other attorneys have reported that they filed a 290B, it's been pending for 2 months, and even though there hasn't been a final decision made on it, the client still got a notice to appear in immigration court. And the problem with that is, for most people, and by that I mean people who were not charged as arriving aliens on their notice to appear, which in this scenario you probably won't be charged as an arriving alien, USCIS loses jurisdiction to make a final decision on that I-485 the moment you're in removal proceedings. So it's just like a catch-22 and there's no way out unless you have an approved I-130 with many of these immigration judges. All right, the final thing I want to discuss in this video is, from the before times. Some people have asked me about it though, and that is, what about prosecutorial discretion? In the biz, we call it PD. PD is when the Department of Homeland Security can exercise favorable discretion to just dismiss the charges of removability. This was a thing with all previous administrations, Democratic or Republican, but right now it doesn't exist. There is no way for the Department of Homeland Security to dismiss the charges of removability against you. They just don't have the power to do it under their current policies and guidance from the higher ups in the Department of Homeland Security. They're trying to get as many removal orders as possible. However, there are some instances where it could still be a decent strategy to try to apply for PD, and that would probably be limited to situations where your removal hearing is going to drag out for several years. In most of the high volume immigration courts, think like the ones in New York City, major metropolitan areas, they've added many more immigration judges and started dramatically accelerating cases. There are some judges who have to do 200 plus preliminary hearings in a single day. There have been reports that they can't even stop for a lunch break, and they'll just go until like 6 p.m., even though it's like a federal judge and they really shouldn't be, it's a federal job. They shouldn't be working that long. But I mean, that's their problem right now. You know, not to disparage these immigration judges. Some of them do it with incredible grace. And I don't know how they've been doing this for 8 hours straight and they still are super polite and still take the time to explain everything to each individual immigrant. So, you know, kudos to them for, you know, treating every immigrant with immense respect under these very difficult conditions that they've been put under. But even with that said, there are still some immigration courts that have cases that are being scheduled years out into the future. And sometimes it's judge specific. There are some judges that have court dates out in 2030. And if you have one of those cases and your case is not accelerated, which it very well may be before 2030, then prosecutorial discretion might come back. And someone who most likely was going to get a removal order might end up being able to just dismiss their case and end up living without a removal order on their file. There's one final point I want to make here. So I just consulted with a husband and wife, U.S. citizen married to an immigrant who entered the U.S. lawfully but who overstayed, and they have an adjustment of status interview scheduled next month. And they are not my clients, but they consulted with me just to get a second opinion because, I don't know, they don't trust their current attorney or something like that. They just wanted to get a second opinion. I'm happy to give it to them. And they asked, what if I withdraw my application for adjustment of status? And my response was, that is absolutely the worst thing that you guys specifically can do in this situation, because to defend you from deportation, you'll need an approved I-130 petition. And if you withdraw your I-485 while you're out of status, you're still going to get a notice to appear. But now you won't have an approved I-130. You have to go to that interview, and the important thing is for the officer to believe that you're in a good faith marriage so that the I-130 petition gets approved. So we need to submit as much evidence as possible to get that I-130 family petition approved. Once it's approved, you'll have options even if you receive a notice to appear in immigration court. Namely, you could apply for adjustment of status again. In this situation, the immigrant spouse has more than 1 year of unlawful presence already. So transferring it to a consulate abroad isn't really going to work unless she's willing to wait 10 years outside of the US because there's an unlawful presence bar, or wait for an unlawful presence waiver to get approved before she re-enters the United States. You can also do an unlawful presence waiver from within the US. It's called an I-601A waiver. But under current policies, it's kind of difficult to get one approved before you leave the United States. And once you leave, it's a different procedure. You could still apply for the waiver and get approved, but you have to do it at the consular processing stage. So it's a little beyond the scope of this video, but those are basically what their options are. So withdrawing an I-485 to try to avoid removal proceedings if you're out of status, not a good option right now under current policies. All right, guys, that brings us to the end of today's video. If you appreciate the content, the biggest favor I have to ask of you is to just like the video, give it a thumbs up, or if you don't like the video, give it a thumbs down. And if there are other topics you want me to address, throw it in the comment section below. I will read them before I create new YouTube videos. And the purpose of these videos is to help educate the immigrant population so that they can make the best decisions for their cases. If you need any assistance with an immigration matter, I focus my practice on family-based adjustment of status and naturalization. It's what I do all day, every day. I don't dabble in other fields of law. So if you want someone who just focuses on this and who handles cases nationwide, you could schedule a consultation directly with me by clicking the link in the video description below. The consultations are not a sales call. The purpose of it is to answer all your questions, create a strategy, and help you feel confident about your decision. Whether that decision is applying now or not applying now, I will not try to convince you to file it if I don't think it's in your best interest, because frankly, that creates more headaches for me, and I don't want to get a call hearing that one of my clients got detained. So if you want a consultation, speak with an attorney who cares about his clients, click the link in the video description below, and I'll see you guys next time for another video.